The views and opinions expressed on this program are those of the participants and do not reflect the views of BronxNet or the program underwriters.
BronxNet. Your voice, your views, your vision.
There are two things I love, law and playing sports. And believe it or not, the two frequently collide. On tonight's show, we discuss a book that just so happens to cover both of my passions. Also, just how secure are your medical records when it comes to future employers? Not as safe as you think. We have much to get to tonight, so stay right here because today's verdict starts right now. Welcome to today's verdict, the show that gives you your legal rights and options. I'm your host and trial attorney for the next 30 minutes, David Lesh. The New York State Bar Association has recently published a resourceful handbook focusing on my two favorite pastimes, law and sports. The book is called In the Arena, and it covers legal issues that currently face today's athletes. Everything from the law of agency, trademarks, and even performance-enhancing drugs are covered by the author, and I was lucky enough to sit down with author and co-editor David Krell to discuss what inspired him to write In the Arena. Let's take a look. Sports law is one of my favorite topics, given the fact that it unites two of my favorite passions, sports and law. But this area of law can be rather complex and certainly informative. One resource has been published by the New York State Bar Association. It's a book titled In the Arena. And joining us today is the co-editor of In the Arena, attorney David Krell. Mr. Krell has several works published covering sports law, pop culture, and he is also the baseball historian for the sportspost.com. Mr. Krell, welcome to the show.
Thanks for having me, David.
I love part of the bio. This is great. You said that you're elected or you're into the National Baseball Hall of Fame not because of your Little League skills, your Stratomatic knowledge, or wiffle ball prowess, but because of your article about the Dodgers stealing home.
Right.
I love that.
Right, thanks.
Okay. What made you get into this field? Tell us a little bit about it.
When I was in law school, there was a Brooklyn Dodgers case. There was a restaurant called the Brooklyn Dodger Bar and Grill. The LA Dodgers, Major League Baseball, they didn't like that. So they hired the powerhouse firm of Wilkie Farr and Gallagher. The restaurant was represented by Fischetti and Russo, and the restaurant won the case. It was a trademark infringement case. The court said, Brooklyn Dodgers are no longer. They left 30 years ago, and you have no rights to the name. Today it might be a different story, but that case always appealed to me. So when I was writing this article series for the Law Journal, Entertainment, Arts, and Sports Law Journal, I wanted to write about that case, and I tried to get an interview with the president of the Hall of Fame. He said, we don't do interviews, but send the article when it's done. We'll make it a part of the permanent collection.
That's wonderful. It's a great story. Now, let's talk about your book. Let's talk about In the Arena.
Right.
Talk about the book. Tell us a little bit about it.
The book covers a wide variety of sports legal issues, concussions, doping, trademarks, publicity. And if you're a sports lawyer, you want this book on your shelf. If you're not a sports lawyer and you want to get into the field, you want this book on your shelf. You can get it at the nysba.org website. I got involved because Alyssa Hecker is my editor at the Entertainment, Arts, and Sports Law Journal. Last year, she emailed me, then called me and said, I'm doing a sports law book. Would you consider being a co-editor? I said, sure. Then she said, would you consider doing a chapter? And I had to think long and hard about what I wanted to do. And I said, do you have a chapter about mascots and licensing? She said, no. I said, that's the chapter I want to do. I want to walk people through a license agreement specific to mascots.
Now, most people think, oh, you're a mascot, you run around the field, and it's all over, it's all fun. But it's not. There are some legal ramifications, and there are rights that you have as a mascot or the team who owns a mascot. Let's talk about a couple of those issues.
Trademark rights. Every time you buy a Mr. Met T-shirt or a Mr. Met hat, the Mets own the trademark on that figure, on that name. So they have to protect that. If you want to start the ultimatemetsfansite.com and you want to start using logos or pictures of Mr. Met, etc., you want to be very, very careful because that's property. It's intellectual property owned by a team. controlled by the league maybe. You have to be very careful that you're not violating any rights. And if you're a sports lawyer representing a team, you certainly want to be careful about alienating fans. Star Trek ran into this problem in the 80s and 90s.
Give me an example.
Well, Star Trek, they're as conscious of their legacy as baseball folks are. Baseball folks love to talk statistics, love to talk stories. Trekkies know everything there is to know about Star Trek. When they went and when people created the internet, when we created the internet, really, the public just exploded it. You had a lot of Trek websites out there. Paramount, which owns Star Trek, was very careful about not alienating these fans because that's the core base. That's
Absolutely.
where they make the money. So same thing with baseball fans. In some cases, the baseball fans might be propelling money to the team. They might be, in some way keeping the legacy alive.
Well, I mean, they're at home, they are playing Stratomatic, and they have the fantasy baseball leagues and all that. You don't want to really make the fans very angry, even if they're trying to participate, but yet you don't own those rights as a fan.
The team owns the rights, and the team needs to consider all ramifications. That's why I always say a lawyer, not just because I am one, but a lawyer needs to be in the room on day one of a marketing campaign. You don't want to be there on day 500 to clean up the mess.
Let's talk about a little bit more about the book in terms
Sure.
of the different chapters.
Right.
I know you have chapters in about concussions and different things. Talk about a little bit about concussions.
Well, concussions is huge. In the past 2 years alone, we've seen this now on the pregame shows in the NFL. We weren't seeing this years ago. Certainly not 5 years ago, not 10 years ago, not 20 years ago. And concussions is becoming a big, big part of football, not just in the pro leagues, but in high school, in college, in junior college. So the leagues really have to get together on these legal issues and what they mean. The future is the future. We don't know what's going to happen, but it's a very serious medical issue as well as a legal issue.
Years ago, it was, you went back into the game, because your coach told you to go back in the game, but...
And now you see these folks who are 50, 60, 70 years old, who are suffering from dementia, suffering from Alzheimer's. Is there a cause and effect? I don't know, but there is a complete maze that lawyers, sports lawyers especially, need to consider when analyzing a concussion-related case. It's not just a cut and dry case like a broken femur or something like that.
I think it's interesting that the research that I'm looking at in terms of the NFL is that it seems that there did come a point where the NFL knew or should have known that after a certain amount of concussions, it was leading to long-term cognitive impairment. Have you read any of this?
Medical expertise differs. Medical opinions differ. The lawyers have to figure out where those medical opinions are just and not just, but I think it's a big step forward for the league to at least acknowledge that, hey, you know what, there's a problem, and we're going to look at this. So I'm hoping that sunshine is the greatest disinfectant, and I hope that we're a lot farther along than we are today.
All right, look, sports and law, it always brings me to Alex Rodriguez. What can I
Right.
tell you? All right, performance-enhancing drugs. Where do you see us going with respect to this particular issue?
When A-Rod made the announcement and the press conference after the decision was handed down, people said this is a horrible day for baseball. This is a black mark for baseball. I think it was a great day for baseball.
Why?
Because it's now out in the open. It's a big step forward to acknowledging that there's a problem. We saw it with Mark McGwire and Sammy Sosa. We saw it with Rafael Palmeiro basically wagging his finger at Congress saying he never used performance-enhancing drugs. But now we have a lot of players being penalized. A-Rod was one of them. He's appealing, as is his right, under the CBA. But at least it's out there. And I think when the conversation is open and the press is covering it and people are talking about it, certain things will happen. We will get a stronger policy in the next CBA.
Look, throughout baseball history, whether it was the Black Sox, you're always going to get individuals who are going to try and get the edge.
Right.
It's always going to happen, and baseball always seems to recover from whenever scandal occurs.
Yeah.
However, this particular scandal, and that's really what it is, it just seems like it just never goes away.
It's never going away in the present because A-Rod is still playing, and he is now the story. He's been the story for the past week or so. That's a problem that they have to acknowledge. If A-Rod went on a tear and hit 450 for the next month and hit 20 home runs in 25 games, people would still be talking about the drug issue. it wouldn't matter.
So, well, let me ask you, what kind of message, by the way, does this even send to the young people who are playing in high school or in
Right.
college? You know, get the edge, go for it, do whatever you can. I mean, these steroids have some long-lasting negative effects.
Well, that's a moral issue, and it's a right issue to raise, but do you consider athletes a role model? Most of the time, they're human beings like anyone else, but this is a case where they, within the construct of the game, cheated to get an edge. And I think Major League Baseball has a definite PR issue to deal with. Whether A-Rod wants to deal with it or not, that's his issue. And it's certainly his right, as I said, to appeal the ruling.
Okay. Once again, your book. Where can we get it?
nysba.org, New York State Bar Association. And as I say, it's a great resource for the sports lawyer or the person who's not in sports law yet and wants to be in there.
And again, it merges my two passions, sports and law. Please come back to the show.
Definitely.
Right?
Thank you.
It's a pleasure.
But they're wrong. Today I'm just an aluminum can, but one day I could be a stadium.
Welcome back. I'm your host, David Lesh. Stay up to date with today's verdict by connecting with us and sending in your questions or comments through Facebook or Twitter using hashtag BXNETVER. Your health records are personal information and are legally protected under laws called HIPAA. But with the advancement of technology, records are now being shared and stored electronically. This raises questions of privacy when it comes to electronic files. Just how safe are they, and can your employer get access to this information? Today we will talk with an expert on employee rights and find out just how much information about you can your employer get access to. But first, let's hear how the Office for Civil Rights of the United States Department of Health and Human Services explains privacy and security when it comes to your medical records.
Electronic health records, privacy and security. Today, more and more of your health information is being stored on computers. Many of these electronic records are created by doctors and hospitals, and they offer plenty of advantages. Doctors say electronic health records make finding and sharing information easier, and for patients, that can mean reducing medical mistakes and getting better care. Whether your health information is maintained in a paper record or an electronic health record, you have the right to keep it private. And that privacy is protected by a law called HIPAA, the Health Insurance Portability and Accountability Act. HIPAA requires that certain healthcare providers keep your electronic health records private and secure. These providers will give you a notice of privacy practices that describes important rights and protections of your health information. Here are a few of the methods these providers may use to protect your health information. Healthcare providers must have access controls, such as passwords or PIN numbers, to look at your records. This means that only doctors and nurses with the right password can see your information. Your records may also be encrypted. That's a way of scrambling the information so it cannot be read by others. So if a laptop is stolen from your doctor's office, no one should be able to read your information. These providers may use software programs that can record every time someone views your health information, what time a person looked at it, and what changes were made. This audit trail makes it possible to track exactly who's reading your records. If you think your health information has been used in a way that's not legal, you have the right to file a complaint. Know your rights. Visit the U.S. Department of Health and Human Services Office for Civil Rights at hhs.gov/OCR to learn more about keeping your health information private.
Joining us today is Stephen Mitchell-Sack. Mr. Sack is known as the employee's lawyer, having over 30 years of experience representing the right of employees in court. He's also the author of the Employee Rights Handbook, and we are happy to have him back on the show. Stephen, thanks for coming back.
It is my pleasure. Thanks for inviting me.
Let's talk about all the sneaky stuff
Yeah.
that the employer does when you go looking for a job.
The trick is, if you're an applicant, not revealing much about yourself in terms of confidential information. You know why?
Why?
Because once you let the genie out of the bottle, you're in trouble.
Give me an example.
Well, you may interview me, and I may have had cancer recently, but I don't want to tell you. You know what? It's my business. You're not allowed to know that, And you're not allowed to use that information in making a decision, which will probably be adverse because you want to probably not hire someone who is going for treatment or may have to go for treatment if I have a relapse.
Well, I have a business to run. I mean, I want my...
But I have privacy rights, and they outweigh your business.
But you can understand what the employer is looking for. The employer wants to see, have you taken sick days in the past? Are there issues at home where somebody else you have to care from?
All those questions are illegal. You're not allowed to ask them, except here's the way employers get around it.
Tell me.
So, Steve, they'll say, tell us about yourself. Well, you might innocently say, I have a wife and I have 2 kids, and recently I was ill, and you may volunteer all that information, and that's a no-no.
Well, if I'm looking as an employee, let's say a potential employee, to protect myself, but I know in my prior employment I have a personnel file filled with insurance forms and different things. How do I make sure?
You have nothing to worry about. It's illegal for the new employer to demand from the ex-employer that information. And under HIPAA, which our viewers just observed, you can't get it. But the problem is that people sometimes reveal information about themselves. I was telling you before we went on that last week I had an interview with a manager of a major company who was just discussing with me whether or not he should hire someone who had cancer, but the person revealed it at the hiring interview. Now they don't want to hire that person. You know what? They'll probably come up with a reason. Just, that had nothing to do with it. Yeah, right. But we had other applicants who had better qualifications. Now, the minute you say that, you're in trouble.
But by the way, there are other federal protections besides HIPAA. I was looking at the American with Disabilities Act.
Yes.
There's the Family Medical Leave Act.
Well, let's talk about the Americans with Disabilities for a minute.
You know,
obesity is a covered disability. So other than seeing that you're 100 pounds overweight, and then an employer cannot necessarily deny you a job because of a disability, because it's apparent.
Well,
it's situations where we reveal confidential information, which we really shouldn't because it's invasion of our privacy.
What if you say or you let your employer know that you're disabled and they provide the requisite ability for you to apply
How
a job?
about you don't tell them that, you get hired, and then you tell them you're disabled, and then they have to reasonably accommodate you because you've hooked them. That's the better way to do it.
Okay, and that's what they do. They give you they give you what you need to perform your position
after you get the job. But if you tell them that you have a disability before you get the job, they can kind of easily figure out how they're not going to hire you and come up with a reasonable justification for that.
Well, I was looking at a few cases where individuals have been hired, the disability has been accommodated, and then they move within the company to an entirely different area.
Yes.
And they don't want the new area to know that they have a disability.
Right.
Do they have a right to make sure that their employer doesn't let the new department know that? They
Once
don't.
you're in there,
that's it.
That's it. And let me just tell you that, employers are very, very smart. They know that they have to reasonably accommodate, and there's a legal definition for that. Like, reasonable accommodations doesn't necessarily mean building a ramp that costs you $1 million if you are a small employer. So you got to look at each particular thing.
What I also found very interesting is this workers' compensation area and how it somehow plays into an employer's right to see whether or not you should be hired. Because, look, if I'm an employer and I know that the potential employee has had many workers' compensation claims on the job, look, I don't want my insurance
But how are they
going to
find that about
Well, that's
that?
what I'm asking you.
No, you should never admit it.
Never admit it.
And when you're the employee, for all of our viewers, pay special attention to the employment application. Do not answer questions that pry into your background in terms of your medical history. Be very careful. Even if, sometimes employers may ask you innocently to give them permission to delve into it, and the answer is don't give it to them.
All right, we got a lot more to get to, but we have to take a quick break. But when we return, we will continue discussing your privacy rights as an employee. We'll be right back.
Hello, I'm Donja Lemon from Open 2.0 on BronxNet, the show by teens, for teens, and about teens. Catch us every Friday at 4:30 and anytime on the web by going to www.bronxnet.org.
Welcome back. I'm your host, David Lesh. Remember that our show is here to serve you, our viewers. So don't forget to connect with us on Facebook and Twitter and tell us what topics or questions you'd like us to cover on the show. We've been discussing health, privacy as protected by HIPAA, and the fine line between what's protected and what your employer can have access to. But did you know that HIPAA laws protect your information by giving you the right to know who is accessing your medical information? Let's find out more from the Office for Civil Rights of the United States Department of Health and Human Services.
The right to access and correct your health information. You may already know that you have the right for your health information to be kept private. This is spelled out in a law called HIPAA, the Health Insurance Portability and Accountability Act. But here's a right that you may not know about. Under HIPAA, you're entitled to see and get a copy of your health records. Sometimes you may not be able to see certain parts of the full record, but you always have the right to ask. Now, once you've looked over your records, you have the right to add any corrections to your information. If you disagree with your doctor or health plan about certain information in your record, you have a right to submit a written statement of disagreement that will be kept with your record. And while you're checking out your records, you also have the right to find out when and why they were shared for certain purposes. Know your rights. To find out more about accessing your health records, visit the U.S. Department of Health and Human Services Office for Civil Rights at hhs.gov/OCR.
Your right to privacy when it comes to the sharing of your medical history with your employer is our topic of discussion. We've been asking attorney Stephen Mitchell-Sack what he believes is the future of our right to protect our medical records. Mr. Sack, thanks for being here. You know what I want to get into a little bit, these wellness programs, right? Tell what the viewers what these programs are.
Well, companies are offering incentives to lose weight, stop smoking, stuff like that. But in order to do that, they're taking polls, and getting personal information that employees are not so willing to give, because why do you want to give them your weight and your height and personal information, right? Because the company wants it so that they can figure out, are you losing weight and is it working, and will you get a benefit from that?
And if they think you're not losing weight, they'll let you go? Is that
Yeah. I mean, no. The real thing is, I think it's an intrusion on people's privacy rights. It's taking back some of the rights that HIPAA offers the individual, and unfortunately, it's being, this is an area that is very unsettled, but companies are trying to take an active role in protecting the health of their workers, and it's not
really working out that way.
Well, it's not flying with the rights of privacy, so we have to be careful.
Listen, you're wearing one particular hat, which I understand, but do you feel that employees, their rights of privacy are being infringed? Are we gaining ground here as an employee, or are we swinging the other way?
No, we're losing ground, and that's a shame. And I'm very much against it because I represent individuals only in my practice.
But why, though? Why are we swinging back to the?
Well, companies are trying to get all the information they can, and the way they're doing it is surreptitiously through these wellness programs. And I say that just because a company thinks they're doing good for you, do you want your own employer to be looking out for you? Maybe you don't want to go on a diet. Maybe you don't want to stop smoking. Whose business is it,
It's always that same balance between wanting to make sure you have a functioning office that does well against the right of an employee to be able to...
But in New York, for example, we have laws that regulate off-premises recreational activities, right? Which means that you can't be fired for smoking off-premises, for drinking off-premises.
But I have the right to ask my employee for a doctor's note if he or she misses work for a couple of days. Don't
Absolutely.
I have a right to do that?
Yeah, but that's just to justify whether or not the person, called in sick legitimately or was taking time off to have fun.
How about some tips? Do you have any tips for the viewers who are watching and they're looking for a job? What would you tell them to do or not to say?
Well, whenever you're going to ask voluntarily, tell me about yourself, be careful not to reveal private information because they're going to use it against you. That's number one. Number two, when you're working at the company, find out about your rights and make sure that your records and your medical history is not automatically disseminated to non-essential third parties.
Yeah, but you can't.
No, you can find out. I mean, they may have issues that HR may come to you and say, David, I need to talk to you, and then that's a clue that maybe they're using some information about you illegally.
So what do you say? I'm not going to talk to HR because
no, but I
need my lawyer with me when I go down to the HR department?
You have to demand to know where they're really coming from and act accordingly. Know that if you have a disability, companies may be taking adverse action against you, you can go to a lawyer like myself, or you can go to the New York City Human Rights Commission and file a claim for disability discrimination if you feel your rights have been violated.
And by the way, you have a book. We have a book here. Okay,
Yes,
it's very important. The Employee Rights Handbook.
Thank you.
Tell us a little about the book.
Well, it's, I've written 19 books for the American public. This is my latest and hopefully greatest work. It's a comprehensive book telling everybody what they need to know before, during, and after their rights with the job have ended.
Okay, and how do they find you?
I'm available. I have an office in New York City, Stephen Mitchell Sack. They can go to my website, stephensack.com. They can email me if they have a question. There's no charge. I'll be happy to get back to people. My email address is stephensack, atty@hotmail.com.
Okay, getting back to the interview process between an employer and an employee, are there times that the employee actually waives away that right?
There are times.
And how does that work?
There's an employment applications that give employers the right to go into your credit, maybe into your health situation if you waive it. So you got to read that application and question some language that you don't approve.
I was looking at one of the particular acts here, which is something that I should have right over here. It's the Federal Fair Credit and Reporting Act.
Yes.
Right. How does that into play with respect to this type of?
Yeah, the only way that employers
rights?
find out about your credit is if you give them information. And they specifically in the employment application will ask you to waive your rights and allow them to investigate, especially if you work in a security-conscious industry or you're dealing with money, okay?
Okay.
Now, if you don't give them that right, they're not going to hire you. They're not going to, as an applicant, they're not going to accept you.
Here's what I think. I think in terms of your credit, many times your credit might not be the greatest because of medical bills that you haven't paid,
Sure.
right?
Sure.
Doesn't that come up on a credit application?
Yes, and also you may have filed for bankruptcy. The federal and state law allows you not to be fired or not offered a job because of your prior bankruptcy record.
But that's bankruptcy. You're not being hired because your credit score is not good, but your credit score is not good because you've had medical issues and you haven't been able to pay your health bills.
That's a very good point. That's why you're the man and you're the
right. So
today's
that's
verdict.
Okay.
No, that's a very smart point.
Okay, where do we get the book?
Okay, online they can get it from my website, stephensack.com.
I love it.
Thank you so much.
And you're going to come back again?
If you invite me.
For the third time. You're always invited. All right, well, that's all for tonight. It's time to deliberate. I'd like to thank both of our guests for joining us, and of course you for watching. Remember, if there's a legal issue or topic you would like to see on the show, email me at davidlesh@bronxnet.org. And until we see you again, always remember, know your rights, know your issues, reach a verdict. We'll see you next time. So, I mean, I love it.
Raymond, look at Mommy.
Maybe the light hurts his eyes.
Maybe she's just not hungry. Maybe he can't hear us. Maybe we're not stimulating him enough. Maybe it's a phase.
Avoiding eye contact is one early sign of autism. Learn the others today. The sooner it's diagnosed, the better.